Hello, everybody. My name is Amanda Shanor. Welcome back to SCOTUS Blog Live. As hopefully you know, we are here to do an educational seminar talking about the recent oral argument on Wednesday in the case Barr v. American Association of Political Consultants. And with me here today is the amazing Genevieve Lakier from the University of Chicago Law School. So what we thought we would do is I would just put a little bit of background on the case, especially for those of you who weren't able to make it to the argument or read that much about it before. And then Genevieve and I will talk about what we thought was interesting, what was surprising, what possibly could have been otherwise. Okay, so just as a reminder, this case is one of only 10 cases that in a really historic and important shift, the Supreme Court is hearing oral arguments on by teleconference. That is perhaps appropriate because this call is actually about telephone calls and particularly robocalls to cell phones. The question before the justices on Wednesday morning was when the oral arguments were heard, is whether or not the Telephone Consumer Protection Act of 1991 or an exception that was added to it in 2015 violates the First Amendment's free speech clause. Okay, so what are these things? So the Telephone Consumer Protection Act bans robocalls to cell phones. And in 2015, Congress passed a different law that added an exception that allowed the government, or I guess it's contractors, to use robocalls to collect debts owed to or guaranteed by the federal government. So basically, it added an exception to the robocall ban. I guess we'll start off now talking about the oral argument, but I thought one of the things that was interesting is with thousands of people tuning in to listen to the oral argument, Chief Justice Roberts called the case and reminded everyone, maybe with some humor in reference to robocalls, to turn off their cell phones. So with that, I guess I'll ask you, Genevieve, what you thought of the argument, what you thought was interesting or surprising.
Well, what was, I guess, interesting, although maybe not that surprising, is the unanimity of the justices on the first issue, which is this exception content-based? Although Justice Breyer had a really interesting set of questions, sort of philosophical questions about what does it mean for something to be content-based, was certainly pushing against the content-based, content-neutral framework, as he has done in a bunch of dissents in recent cases. Even he wasn't making an argument really that the government debt exception is content neutral. He was more just problematizing the distinction. It seems like there's 9-0 votes in favor of, with maybe a tiny exception with Ginsburg, suggesting that maybe this is a manner exception. But on the whole, the vast majority of the court seems totally sold on the content-based nature of the government debt exception, which produced, I mean, it had a strange effect, I think, on the arguments, because I think the government lawyer came in prepared to really argue about the content-based, content-neutral nature of this, and then that just so was not working. And so the entire argument became about this other thing, which officially was about severability. Can you sever the exception? Can you sever this government debt exception to the general ban on robocalls from the rest of the statute, or does the whole statute have to fall? But by the end of the arguments, that had really become an argument about whether the statute as a whole is unconstitutional because it doesn't further a sufficiently important government interest and is not narrowly tailored. And by the end, the plaintiffs in the case seem to be making an argument that it's really not that solely the government debt exception is content-based, but that makes us really skeptical of Congress's motives or the necessity of the statute to begin with. But that's really weird because they didn't make an argument in the brief that the statute as a whole fails as a content-neutral regulation of speech under intermediate scrutiny. And so it's a little surprise. They were just trying to jam this into the severability analysis. And so I found that surprising, and I'm not sure it's going to be successful. What do you think?
Yeah, so let's back up in case people don't know some more things about the case. So I should have said to begin with, there are two major issues, okay, in the case. And one is whether or not, and the parties frame the first question differently, whether or not either the exception, the government debt exception, which allows certain sort of an exception to the general robocall ban, is unconstitutional under the First Amendment as being content-based and therefore subject to more heightened scrutiny, or as the plaintiffs frame it, as whether or not the ban itself is unconstitutional. And I think Genevieve and I both agree that we should really talk about that. And then second, if one or both are unconstitutional, what's the correct remedy? Most importantly, should the exception be severed from the rest of the act, which would mean we all don't have to keep getting robocalls. Okay, so if the exception is struck, it means that government debt people can't call you on your cell phone. Whereas if they strike down the whole law, that means we can all get a bunch of robocalls on our cell phones. And also important for background, the people in this case are not debt collectors. These people want to make political robocalls. So they want to call about stuff related to the 2020 elections and are not allowed to do so because of the general ban. But they are not actually affected by the exception, which allows government debt collecting robocalls. Okay, this puts them in a weird position. And just as Genevieve was saying, what is fascinating is how they litigated it and then how the court and I think the SG's office approached the question. So essentially, sort of for background, the general robocall ban has previously been upheld as a content neutral regulation. That means they're not in a great, the political robocall guys are not in a great position to challenge the ban that affects them. But because this other exception about other people was added later, they say that makes the law content-based, and so they should get strict scrutiny. Okay, so let's see, Genevieve, what you think. But basically, I agree with Genevieve completely that what was interesting about the arguments, or at broadest level, was that the vast majority of the questions were about the second question, severability, suggesting that the majority of the court thinks that at least the exception is content-based and unconstitutional. And so the question is, what should be done? Should they strike the exception or should they strike down the whole law? And we can talk about if that's a good thing, a bad thing, a necessary thing, but that in part that has to do with how it was litigated.
Yeah, and I felt like at arguments, there were two separate arguments about severability that the court was batting around, and I thought they were interesting about why, or at least arguments in favor of striking down the whole statute. Because, I mean, at first blush, and I think this is probably likely what the court's going to do, it's one exception to a much broader statutory regime. It's an exception that was added much later after the original law. And there is a severability clause that says if any portion of the statute is found to be unconstitutional, please sever it. So it seems like there's a pretty explicit expression of congressional intent. And the general rule when you're doing severability analysis is you're trying to get to congressional intent, trying to figure out what Congress would have wanted. And so there's lots and lots of reasons to think the severability analysis should be a really straightforward one, that this is a super easy case. The court thinks that it's a content-based, the exception is content-based, and therefore can only satisfy strict scrutiny.
Okay, we appear to have lost Genevieve. Hopefully we will get Genevieve back. So I guess I'll tell you other things and hopefully that I think, and hopefully we'll get Genevieve for much more illuminating commentary. But the sort of like one of the main things that I came away with from the argument was also sort of like the general feeling on the court that they had very little taste for the idea of overturning the entire robocall ban. There was like a very, I thought, interesting question or comment from the Chief Justice in which he basically said, this is a law that's been around for 25 years. It's an incredibly popular law. Let's see if I can find the actual quote. He says,
I'm back.
Are you back, Genevieve, now?
Yes, really sorry about that. I have not had any internet problems the whole week, but now is when they arrive.
Probably you got a robocall.
Probably like that.
So one other thing I should say is during the argument, a couple interesting things happened on this technological front. We had one in which Justice Breyer's connection didn't work. And so when he was called upon by the Chief Justice, he was not able to answer apparently because he got a different call. And then one of the more interesting moments was when we heard a toilet flush in the background while a justice was asking a question. But yeah. even despite those things, I thought it was, at least for me, I thought it was, the court has done remarkably well. And it's been wonderful to actually be able to hear the arguments live.
Oh, I thought it was fantastic. And I also think it was interesting to see how the questions build on one another. at least in this argument, because almost everyone seemed on the same page on the sort of the first question about whether this government debt exception is content-based. It felt a little bit like a seminar where the justices were really talking as much to each other as to the lawyers and trying to figure out how to think about the severability question. And that felt really productive. Okay, can I go back to what I was saying?
Yeah, go back to what you're saying.
Okay. So in theory, the severability analysis, I think should be really straightforward. And I assume that that's what the conclusion the court's going to reach, which is not going to provide the relief that the petitioners, that the respondents or the plaintiffs in this case want. But so they were trying to work really hard to avoid that conclusion, which I think is the more straightforward conclusion, by making, I thought, two interesting arguments about why you should strike down the whole thing. The one was this sort of, the First Amendment severability analysis is different because you want to protect more speech rather than less speech. And I think at some point, Justice Gorsuch says something like, you want to liberate the speech that has been restricted. It's like the speech is like desperate to be free, which that was amazing, interesting. And so the court seemed to be taking that, they would think, a number of justices in the court seem to be taking seriously this idea about, well, maybe First Amendment cases, the severability analysis is just different. Now, the court has never endorsed that. And in fact, I was just looking, in a bunch of relatively recent First Amendment cases, it has performed the severability analysis like exactly as it does in other constitutional cases, simply by thinking about congressional intent. So I would be surprised if that's what actually makes it into the opinion. It would be a really significant change in the current approach, but it was a persistent theme in the cases. Wait, and then there was,
Can I add something that, so I agree with you. I thought that was interesting. I mean, a number of justices, off the top of my head, Justice Gorsuch and Justice Alito asked questions in this vein, particularly, should the leveling up versus leveling down analysis be different for equal protection cases than First Amendment cases? Where it makes sense, they say, it makes sense to level up or down in equal protection because you're just trying to make the parties equal, even if they both end up worse, okay, as opposed to the First Amendment where we're trying to liberate the speech, right? And even Justice Ginsburg raised a question that's like, why would anyone challenge a content-based law if you're going to get no remedy? Okay, there was that kind of theme. But I think doctrinally that makes no sense, right? Because of course, the whole problem with a content-based law is the content-based nature of it. And so if you level down to a content-neutral law, that would seem to be no problem if that is consistent with congressional intent, which, as the government points out, is the touchstone of any normal severability analysis. Do you agree with that?
I agree. And a number of justices, including Justice Kavanaugh, who I would have thought would have been on this liberate the repressed speech train, expressed a concern about the radical implications of severing or striking down the whole statute. The justices kept coming back to the fact that this is a really popular statute. They don't want robocalls. So it didn't seem like there was enough appetite among the justices on the court to reach their conclusion. And I agree, it doesn't make any sense. And also the argument that people kept making, including Justice Ginsburg, litigants would have no incentive to bring claims. Well, that's true, as I think the government lawyer argued well. That's true in all kinds of cases where you can win on one issue but not on the other. And so the idea that we have to tailor make it so that people are fully rewarded for bringing this litigation didn't seem like a very plausible argument. But the plaintiffs in the case, they didn't rest solely on this, the First Amendment is so special kind of argument. I thought, interestingly enough, and this is where we get to the sort of sneak attack on the statute as a whole, the lawyer kept arguing that, well, the fact that Congress enacted this content-based exception cast doubt on the seriousness of its intent to begin with. And so the reason we should strike down the whole statute is because this government debt exception makes us rethink how serious Congress was in the first place about protecting consumer privacy or residential privacy. And maybe if it doesn't have a good enough reason, then we should strike down the whole statute. Now, I didn't find that convincing either, because we know that the government debt exception was added much later. It's pretty narrow. Congress might both want to protect privacy and also want the government to collect its debts. But it was a pretty clever way, I thought, of sneaking in, I think, a facial challenge to the statute as a whole without having to engage in a kind of how would the statute be evaluated under the much more deferential scrutiny that is applied to content neutral regulations of speech. Yeah. Thoughts about that aspect of the
Yeah,
severability
I thought
conversation?
that was interesting. I actually, the thing that so I think it's clever, right? Like that was like a clever lawyering move on behalf of the consultants. I
Yeah.
thought what was interesting was that that the SG's office didn't call them out on that.
Mm-hmm.
More because I think, I mean, and I like the Deputy Solicitor General Malcolm Stewart, who is arguing, is like a very seasoned advocate, and in his rebuttal he basically makes this point
Mm-hmm.
that essentially, and one thing interesting I thought was that the lawyers for the consultants concede essentially that like a content neutral law gets relatively lax intermediate scrutiny, and if this was just a restriction or a regulation of government debt collection, it would get into intermediate scrutiny. And so there's something kind of weird and inconsistent about their argument. And it wasn't until really the rebuttal that I thought that the Deputy Solicitor General really kind of got to that point.
Well, I thought it was interesting that they were both sides, I thought like could have been making stronger arguments than they were making.
Yeah.
So the government, for its part, it didn't even argue that if the exception is content-based, it could satisfy strict scrutiny, even though the district court that heard this case originally reached that exact conclusion. It applied a strict scrutiny analysis and it found that it survived it because it was so sympathetic to the aims that Congress was trying to achieve, and it thought that the exception was pretty narrow. And so maybe you think the Supreme Court's not likely to do this, and it's true, but it was strange to me that they don't even try. They just concede that if this is content-based, it's unconstitutional. But on the other hand, the plaintiffs in the case, they focus solely on this government debt exception, which makes it very easy for, I think, for the government to argue, well, you should just sever. Say it is content-based, this was enacted later, it's not an integral part of the scheme, just get rid of it. When in fact, other courts have found that other portions of the TCPA are content-based, and there's this exception for calls that are related to emergency calls. There have been some courts that have found that that's content-based because you can only know that a call is about an emergency if you look at the content of the call. Now that's a very expansive, very sort of literal reading of what it means to be content-based, and maybe the court wouldn't have gone for it. But it does feel like the plaintiffs in this case, they put all their eggs in one basket. And then when they started to realize that that's not going to get them as far as they want to go, because even if they win on the government debt exception, it's just going to be severed from the rest of the statute, and they're still not going to be able to make political robocalls. They try and find these kinds of creative but maybe sneaky ways of escaping the box. But they didn't need to make that box to begin with. They could have challenged the content neutrality of the law. I mean, there's a secondary issue in this case, which you could think would have been a bigger deal than it came out to be in the arguments, which is how compelling is a government interest in privacy? You know, there's been a lot of concern by First Amendment scholars that in First Amendment cases, the court in recent years has not taken privacy interest very seriously. And so you could imagine an argument that, well, Congress this privacy isn't a sufficiently compelling or important interest to justify this very significant restriction on robocalls. But they didn't do that either. And so it seems unlikely that the court's going to reach any interesting conclusions about the nature of the government's interests here.
Though I don't know. I mean, we'll see. It kind of depends on how they approach it, and if they do, as it sort of seems most likely, find that the exception is content-based or makes the statute content-based, however they frame it, and then sever it, whether they sort of like do any sort of analysis about the statute, sort of the underlying ban itself. Yeah. And from my recollection, Justice Thomas did ask a question about the government's privacy interest, and Roman Martinez, who actually, I think I know him from law school anyway, argued that essentially that one of the things that undermines the government's privacy interest is not just the exception, but also that the robocall ban for residents, is the landline one, doesn't exclude non-commercial and political speech or doesn't ban non-commercial and political speech in the way that the cell phone one did. And I thought that the Deputy SG's response was really good. He basically said, there's an even greater privacy interest against robocalls to your cell phones that is different maybe even than when it was passed, insofar as everybody carries their phone with them all the time. And so this is an even greater restriction, an even greater invasion of privacy. And I thought that was a very good practical point that hit home and resonated with a lot of the things that I thought was really interesting. Both the Chief and Justice Kavanaugh made really strong points that were sort of like, about the practical implication of this, that nobody likes robocalls to their cell phones. And, Justice Kavanaugh really aggressively at the end was like, do you want to fight with me about about the common sense nature of that notion?
Yeah, although I have to say, if I were a litigator, I have no experience litigating in the Supreme Court, but I would have fought with him on that common sense nature, because this is core political speech that the plaintiffs want to engage in. Robocalls, they are super annoying, but they also make it much more inexpensive to disseminate a political message widely. And so it's actually not, I was surprised. Kavanaugh, I think of him as sort of a libertarian First Amendment judge, but really seemed to favor the robocall limits in the TCPA. And I wonder if they could have been more if the briefs had been more explicit and had spent more time explaining why, even if we don't like robocalls, why they are actually an incredibly important means of communicating political messages, if they could have made more headway. But by focusing everything on the government debt exception, they kind of deflected attention from, I think, what is at the core of the case, but sort of somehow has been shuffled, has become somehow secondary because of the sort of the doctrine, which is this is the government restricting political speech, core political speech, and make it more expensive.
Yeah,
right in that, yes, right before presidential election. And it looks like, if we can read the tea leaves from the argument, it looks like the TCPA is going to survive, and so the government is going to continue to be able to, in effect, make it much more expensive to send out these political campaigning messages via telephone.
And that includes not just cell phone calls, which is essentially what they were talking about, but it also includes text messages to your cell phone. And I think, that, I don't know about you, but I'm now getting a bunch of those things. And I think we would get a lot of them if the case came out differently than at least it appeared at the argument.
Yeah, and so it's sort of surprising that what I think of definitely as a very sort of speech protective libertarian First Amendment-y court seemed actually pretty committed to the TCPA. Seem to believe in its common sense nature.
Exactly. And I think one of the interesting things to me, and you and I have both been talking a lot and writing a lot about the relatively libertarian nature, free speech nature of this court. Yeah. And I agree with you that was interesting. And part of the thing that I've been wondering is whether or not this court is at least beginning to see some limits to its libertarian or its commitment to an aggressively libertarian First Amendment. And this case, and robocalls to your cell phones, may be one of them. And I think it will be interesting to see how they discuss Reed. So for background, everyone, Reed is this 2015 opinion that articulates an arguably new, broader rule for when a law is content-based and presumptively unconstitutional that could be read very broadly, could be read more narrowly, in ways that could even sort of like undermine a whole bunch of First Amendment case law. I think most prominently and sort of most aggressively litigated now about commercial speech. And some of the questions it's one of the questions in this case is how to read Reed. So the justices were on a phone call about phone calls, talking about how to read Reed. But that was interesting. And I think one thing, Genevieve, you and I talked about before was it was interesting that only really two justices, Justice Breyer and Justice Kagan, really were engaging directly with the question of sort of how to read Reed and whether or not we should limit the sort of, or how we should think about that, except insofar as some of the justices seem uninterested in striking down the TCPA ban.
Yeah, I mean, I think initially I thought that this case might be a really interesting vehicle for elaborating or thinking more carefully or critically about Reed, now that we're 5 years out from the initial decision. But it looks like the majority of the courts just committed, they're going to apply Reed or that they were applying Reed in the arguments and concluding that the law is content-based, but that actually doesn't solve most of the interesting issues of this case, because the interesting issues of this case are raised by the non-content based, the content neutral or apparently content neutral aspects of the statute. And so I guess I will say if the court ultimately upholds the TCPA, which from the arguments just seems like the likelier than not solution or conclusion, it suggests that this distinction between content-based and content neutral, it not only gives the government it gives the court a lot of power to strike down laws that it deems content-based, but under the content neutral framework, the government actually has a lot of power to restrict a lot of speech. I mean, the TCPA is an excellent example. if we get rid of the government debt exception, it's still restricting a huge amount of calls, but because we
including core political speech.
Including core political speech. And
right.
This is actually sort of a complicated consequence of the content-based, content-neutral distinction that the court's been really committed to in the last few decades, that I think gets underappreciated, that this is a libertarian free speech court insofar as its ideology. This is how it talks about the First Amendment, this is how it thinks about it. It's about liberating the repressed speech. But in fact, the formalism of its content-based, content-neutral distinction, this sort of very central distinction that everyone on the court seems committed to, except maybe Justice Breyer, and then Justice Kagan was expressing some doubts about how to read it. Actually, it gives the government, it leaves a lot of room for the government to restrict a lot of speech, so long as it does it content neutrally. Mm-hmm. We got a question about severability and whether you think that whether we think that the discussion about severability has any implications for the ACA case.
Yeah, so I had thought that before. I'm interested to hear what you think, Genevieve. I had really thought we might sort of like hear in the justices' questions actually a debate about how to approach the severability question in the ACA case. And I was surprised that, in fact, I didn't see as much of that. And maybe when we see how it's written, we'll see more of that. But I thought they were more focused on this question of like, should we level up? Should we level down? Should we liberate speech? Is the First Amendment the same as equal protection? Why or why not? Yeah. And I don't know if that's just because that's more interesting now or something else, but I saw less of kind of like, let's talk about the general rules for severability as opposed to the ones particularly at stake in the First Amendment. But what did you think, Genevieve?
I agree. There was one moment where Martinez suggested that even if this isn't, even if we're not going to have a separate First Amendment severability analysis, when we're thinking about congressional intent, we have to have very specific markers of congressional intent, more than what seems to me pretty specific markers in this statute. And that seemed to me a moment where, wow, if the court buys that, it could have implications for the ACA. But otherwise, yeah, in fact, what was remarkable is how very First Amendment centric the severability discussion was, which makes me think that in fact it really was all a dodge, a workaround, a way of talking about the sort of fundamental validity of the statute writ large under the First Amendment, and wasn't really about severability as a general matter, as a cross constitutional law issue.
Right. And I think part of that too was also that Martinez, with the political consultants, lawyers, was really trying to make the severability question actually about the sort of like the constitutional validity of the entire law. And so he would like pivot away from severability into this question of whether or not the whole law was constitutional. I thought there was a great hypothetical from Justice Alito about whether or not, if there was, the same kind of robocall ban and the government had an exception for a robocall at like exactly noon on July 4th, it said, "Happy Birthday, America." Would that mean that you would have to strike? Basically, if you have this ban and it's 25 years old and then Congress passes this new, Happy Birthday, America exception, would that require the court to strike down the whole original ban? And if it had a severability clause like the CPA does. And I thought it was interesting that, Martinez was like, yes, you would have to strike down the whole ban. And Alito was like, that seems to totally make irrelevant congressional intent. So suggesting that there's the kind of severability, generally, they seem more comfortable with, I think, like a traditional severability analysis.
Yeah, I mean, hindsight is 2020, but it does seem like the strategy that the plaintiffs took, which was to focus everything on the government debt exception, and then which is a strong argument that it's content-based, and it looks like they're going to win on that, but then use that as a way of striking down the whole statute, sort of bootstrapping them into a much a bigger decision. It's a strange, it seems like a very risky approach. And I just find it surprising that they thought that that was the best way of getting at what they wanted.
Yeah. Okay, I see we have another question. I was surprised that nobody questioned the rationality or reasonableness of the exception's purpose. And that is that robocalling would cause debtors to pay up to the tune of $100 million more, right? So this is interesting. and this kind of goes to what Genevieve was saying, is that the government didn't actually defend the exception under strict scrutiny, which, that's a lot of money. And the district court had thought that was essentially enough money to meet strict scrutiny. So I think part of why it wasn't discussed at oral argument was because of the government's litigation position that they weren't going to defend the exception under strict scrutiny, which again seems like a weird choice, at least to me.
Yeah, I mean, Justice Kagan did talk a tiny bit about it, but it was more it wasn't critiquing, it was kind of defending the exception. She said, why should we treat this as a content-based exception when it's not about animus? The government's not trying to censor any speech. It's just trying to collect some money. It's just trying to get money into the government fisc. Why should that be a concern for us? But she was really the only one to go there because the government just has not made it an issue in the case, strangely enough.
I feel so sad. I think we're supposed to wrap up.
Yeah.
I could talk to Genevieve forever about this case and the First Amendment more broadly. Okay.
So, but should we end up predictions? What do you think is going to happen?
Predictions. So in terms of vote counts or just in terms of the opinion? In terms of opinion, I think.
Let's do both.
Oh my God. Okay.
I don't know, that's really hard.
Opinion, I feel I feel like I could place some money on the idea that the court is going to find the exception or the statute with the exception content-based and therefore unconstitutional. Cite read. I'm hoping maybe saying we don't have to reach a bunch of these other questions about read and commercial speech, blah, blah. Also, interesting note, Martinez conceded that commercial speech still gets intermediate scrutiny after read. I think that's interesting. It's also doctrinally correct. And I would love it if the court would say that because it would help the lower courts a lot. And I think that then they're going to sever it because I could say something doctrinal, but I think in a not insignificant part because nobody wants robocalls to their cell phones.
Yeah, I think I agree. I think the interesting thing, and this goes to the vote counting, although I'm not going to do vote counting. I have the same prediction, but my guess is that Breyer and maybe Kagan, he's going to write a concurrence because it sounds like Breyer's still not convinced about Reed. Yes. And so it's probably, it seemed like was not sympathetic to the government's position on the exception, or who knows, but seemed unwilling to go along with the Reed point, but also didn't seem to think that the statute should be strict. It's hard to tell what Breyer thinks about the statute in general. So I think Breyer and Kagan are a little bit the dark horses, but everyone else seems very clearly on board with that.
Yeah, but I guess one of the things that's interesting is I do think that there's a way that even those justices can read in this case to be not as broad and therefore not as problematic. And the fact that Martinez concedes the major thing that Justice Breyer is concerned about, which is that Reed will undo the commercial speech doctrine and that Reed will undermine normal conduct regulation. So regulation of economic conduct will become a First Amendment case in all contexts, because of course, under normal, then this was also one of the questions, under normal constitutional principles, economic conduct should get rational basis review, not intermediate scrutiny or strict scrutiny under the First Amendment, even though we've seen this sort of arguable Lockerization or what have you, aggressive libertarianism of the First Amendment into economic regulation. And I think that there's a way that either the court or Breyer or Kagan writing separately might sort of make that clear that you can have Reed and it's not going to eat up everything. And I think that would be great.
We will see.
We will see. Okay. Thank you all for coming.
Thanks everyone. This is fun.
Yeah, it's great.
Bye.
Bye.